Hi, thank you for tuning in. This is a presentation about how UK opposition and invalidity proceedings work and how you can improve your outcomes. So why am I giving this presentation? Well, I come across a lot of oppositions and I'm against a lot of opponents where they're weak cases, where clearly a lot of money's been spent, and where I hope you can improve the outcomes that you're going to get, both in terms of spending less and getting more wins. So why do I think I can say that? Well, I'm one of a small handful of UK chartered trademark attorneys who do their own hearings at the UK Intellectual Property Office. Now, over the last 5 years, I'm in the top couple of attorneys by the amount of hearings, and I'm the actual top over the last 3 years. I keep a very good win rate, which is well over 80% and is just touching on the 90%. And I also appear in court. So I often see what happens in those cases, what goes wrong, and how to prepare and present my own cases and those of other people in the best possible light. So what kind of cases are we talking about? Well, we're talking about oppositions to and by third parties to applications in the UK Intellectual Property Office. So those are ones where they're trying to stop them ever getting registered. And then secondly, invalidations by or to third-party registrations, which is to have them treated as if they've never been registered, because in truth, if you'd known about them at the application stage, you would have probably opposed them. So how does it work and how does it go wrong? Well, the standard UK case that you tend to see can probably be summed up in just a few quick pictures. Firstly, people tend to claim really, really broadly. They'll claim that everything is similar to everything else. They'll say they've got oodles of unregistered rights and use. They'll say they've got massive repute, and they'll often argue that two marks that really aren't that similar are either highly similar or identical. So things haven't started off on a great foot. So then what happens is it tends to move forward, and these pleadings that perhaps weren't the best don't get changed, and you proceed through to the evidence rounds where you need to support your case. And evidence that's produced often will miss the mark. And what you're effectively doing is driving right off a cliff towards a rather sticky end. And then finally you end up at final submissions or a hearing where you've got a large number of issues, all of which are ready collectively to do you in. None of them are great. If there is a good case in there, it's hidden beneath a sea of terrible arguments. Or alternatively, you might have a hearing where you've got a really skilled advocate, you've paid really well for a barrister who's a really, really quality lawyer, but he isn't really assisted by the fact that rather than just having a great case to argue, he's having to wade through a case which is like a lake of treacle. So where does it go wrong? Well, as I've said, it starts at the claim stage. When they come in, these claims tend to be very, very broad, and often the claims that are made aren't particularised, so there's no explanation as to why the opponent is saying what they're saying. So why do people do it that way? Well, first of all, it's not unusual to get instructions last minute, and so what the attorney might be doing is just making sure they put in as many claims as possible, pending better instructions from the client. Secondly, you don't get a lot of money back for drafting your grounds well. The UKIPO has a set list of fees if you're successful, or that you have to pay if you're unsuccessful to the other side. And the fees for the first statement are between £200 and £650 in most cases. So with lawyers' fees not being cheap, that doesn't mean a huge amount of time can be recovered. Now, they might also claim big because you're hoping at some point that you're going to get a settlement. So if you claim a large number of things and the other side aren't going to know whether or not you're going to be able to prove that, what's called asymmetry of information, then you might have a stronger hand, because the other side might be thinking, well, God, if they can show all these things, then we're definitely going to lose, so let's try and settle now. But the problem with that is that, well, with the internet being as it is, there is this so-called asymmetry of information is very quickly disappearing. People can find out quite cheaply and quite quickly whether or not the claims that you make are going to stand up or not. And to be honest, where you're acting for a large client, somebody who's got funds, it was never really a massive threat anyway, because that larger client always had the funds to go and find out what the truth was. Now, the main problem that comes from that is that it becomes unclear what facts, in your case, if you're the opponent, what facts about the background, about what you do and what they do, are going to help the case that you want to bring. So what would you do to try and put that right? Well, one thing which you can use is a similarity table, and this is what one looks like. Now, there's nothing particularly special about this table. As you can see, all it does is it just clarifies what goods or services you're opposing in the other side's application, and then just identifies why you think that is and what goods and services you've got. Now, the most important part, I think, is at the end, why you say it's similar and what evidence might be required. So you're already thinking about the next stage, the evidence stage, and thinking, what kind of things do I need to find in order to make my opposition win, or give it the best chance of winning at least. This is the step that a lot of people forget to do. So how bad is it to have these vague pleadings? Well, it's not inherently that bad if you need to do it, but there are some things that you need to remember. First of all, the UKIPO is asking for that extra information. What goods and services you think are similar to what other goods and services, why you're saying that there would be detriment, why you're saying that unfair advantage would be taken. They're asking for that information up front far more often, so you do need to have it all in mind. Secondly, if you're just doing a vague set of pleadings, you're not really setting the scene. You're not setting the case up in that very first document to lead the eventual decision maker to the outcome that you want. It can be setting you up to waste time on really bad arguments. Now, that might seem an obvious thing to say, but it's so rare that the attorneys involved go back and look at their pleadings. And if they're using these pleadings as their basis for the evidence that they're going to ask for from you, the likelihood is they're going to be wasting time on bad arguments. Now, you might not get all of your costs back from getting your statement right at the outset, but if you set your lawyers off, or if your lawyers go off on a bad tangent and they're pulling evidence that's not relevant, or it's not very good, or it's not your best case, then you really are burning time and money. You're burning money from having to spend it on the lawyers, and you might be being asked to go and find bits of evidence and ask people in your business for bits of information that, to be honest, you don't really need, or to be honest, aren't really going to assist your case. So you're asking people to do things, and you're having to use your own time up to find evidence that's just not good. And of course, what it also does, on the contrary, is it doesn't focus on your good arguments. And what you really want to do is you want to get the decision maker to the decision you want in the quickest and cheapest time possible. And finally, it pushes back critically considering the case. Now, that's part of the same thing as bad arguments and good arguments. But of course, if you're not critically considering your case, you don't even know what are your good arguments and your bad arguments. So now you've got your statements of case sorted. What should you be expecting when you get to the evidence rounds? Well, in the UK Intellectual Property Office, evidence rounds are generally sequential, which for those that don't understand means that the first party will put their evidence in. That's usually the opponent, or if it's an invalidity action, then it'll be the person trying to invalidate the third party right. So what that will mean is that in cases where you've got disputed facts, you will get to see the other side's evidence before you need to put your own evidence in, or before you even need to decide if you want to put any evidence in. You will get to see it. That has a really big benefit in that you can, if they focus their arguments, you can focus your arguments. A cross-examination on that evidence is not guaranteed. I would say that you should expect not to be able to cross-examine. Most of the time, the evidence that's going to be put in is not by other people is not going to be stuff which you'd probably cross-examine on anyway, because all you're going to be doing, if they're putting in turnover figures or they're putting in what their marketing spend is, what are you going to challenge them? You're going to say, well, you didn't spend that money, did you? And they're going to say, yes, we did. And there's not much more you can say. Now, the evidence that you'll get in will be substantially lower quality and less detailed than you'd get in court proceedings. And part of the reason for the lower amount of volume is that in the UKIPO there are page limits. So if you are the opponent, so if you're the party bringing the opposition, or if you're the applicant for invalidity, the person bringing the case to try and cancel off that registration, then you will be able to put in 300 pages of evidence. Now that's not including the witness statement, that's just the evidence that comes with it. You can ask for more pages, you can make an application to do that, but the UK Intellectual Property Office takes the view that if you've got a decent case, you can make it in 300 pages. And that comes with benefits, and it comes with problems, which I'll come on to. Now, the next thing is that you need to know that most attorneys have little experience in preparing witness statements for cases that are going to go to a full hearing. So we've done the numbers internally, and only 8% of UK trademark firms have had an average of more than 2 cases per year go to a hearing over the last 5 years. And that's 2 cases per firm, not per fee earner. So if you remember the size of some of these firms, the cases that are actually going to a hearing and that actually get in front of the particular fee earner that you might be dealing with are minuscule. So they really don't have day-to-day experience of preparing witness statements for these cases, regardless of what they say. And again, limited cost award. So for doing the evidence, there is on the scale of costs, you're looking at £500 to £2,200 of costs. So in a case where you're bringing a lot of different grounds and you're not really being very specific about what you say, or the lawyers are doing a lot of work, that is going to be absolutely blown out of the water. So when you're putting your evidence together, what do you need to remember? Well, first of all, you don't always need to put evidence in. If you are arguing about non-specialist goods, so say for example you're a fashion company and you're arguing about somebody else wanting to, use a trademark on cosmetics, the hearing officer is going to understand the general market for those products. So you don't necessarily need to put in evidence about the fact that some products are similar to the others, but you might, maybe it's a different example, but you might want to show the example of how many of the retail stores actually do stock cosmetics or skincare or those things, on the way to the till or in front of the till. There are things like that. Right. Secondly, the witness, if you are going to put witness statement in, the witness should always be the best person that you can get to give the evidence. And the main issues that people don't always think about, they just, when they're choosing their witness, is have they been at the company sometime? If the witness has only been there for 5 minutes, then the level to which they're giving evidence from their own knowledge is obviously going to be minimal. You want to know that they understand the sector. So if they have been at another company before that, they've been in the sector for a while, make sure you say why, because you're setting the ground for them being able to give observations. Because, say for example, there is something which isn't there, you can't put your finger on some evidence, but you can say, oh well, actually this behaviour is standard in the industry. Well, if you've been in the industry for a long time, you can say that, and then you're more shielded from the other side saying, well, the witness would say that, wouldn't they, just to improve their case. You want someone who's going to come across well, because they might be cross-examined. I can't promise that they won't be cross-examined. And when you think about that, you want someone who's not going to be too introverted, because if they're very, very introverted when they are being cross-examined, there might be a perception that they're thinking about their answers rather than being truthful. But you also don't want them to be too confident and too loose-lipped, because they might say something in a moment just trying to get an answer out that actually hurts your case. And the last thing to remember is, if somebody's not giving evidence from their own knowledge, they have to give the source of their information. And most importantly, why you can trust that source. Most of the time that comes where, for example, somebody who's an in-house counsel is giving financial details, or is saying how many people follow their accounts, or how many people follow their accounts that are from the UK. They have to say where they're getting that information from, and the more credible they can make that source, the better. So once you've got that, how do you tighten up the evidence? Because, to be honest, most of the stuff I've just said you'll see in the top 50% of evidence. How do you get it even better? Well, the first part is to remember to tie it all together logically. And the best thing to have in your mind is the line, and that is important, because where we see this is when people are putting together evidence as the opponent, they'll often put in things like the turnover of the business, the marketing spend, and some examples of what some of their marketing. Because sometimes that's because the attorney thinks that is what evidence needs to be put in. That's not the case, because that's not the test. The turnover, the marketing spend, and the examples of marketing all go to show the end bit, which is that the markers become more well known through use. Well, if you can show other things, or if you can show how that all ties together, that makes it all the more credible. If all you have is a blank witness statement, blank by which I mean there's no real story, there's no thread, and you just go, there was this turnover, there was this marketing spend, there were these examples of marketing, and that's the end of it, you're really missing a trick. You're not tying it together. Second bit, you look at the holes in your evidence. So you need to look at if there are any logical gaps. So if you are making certain assertions and you just haven't put enough bits of evidence in, well, you've got two options. Either you try and find the evidence or something which points to the same thing, or you ask the witness to make the assertion and where they're getting that opinion from. Now, if you've chosen the right person to give the evidence, that's not a problem. Secondly, you need to deal with any missing evidence or small evidence. Now, I see it quite a lot with fashion clients now. Their marketing spend might not be that big. They might have quite a big turnover, marketing spend not so big, and the reason is because the way in which they market is not the traditional way of print advertising and TV advertising. What they're actually doing is they're using Instagram, they're using influencers, they're using paid advertorials, they're using product placement into certain magazines. All of these things that are a lot cheaper mean that the marketing spend is that much lower. So the other side are wanting to think that actually you've got not a lot of marketing spend, but actually what you want to do is you want to say, no, that looks like a small figure, but in reality, here is what the outcome is, and this is the way that the market now works. So you need to put that in. And then finally, if the evidence doesn't show what you want, you need to explain away why it isn't there, or why it doesn't show what you want. Most importantly, show why it matters. So, for example, the fashion example I just did, if you are saying, well, look, I've got this many influencers, I've paid for this influencer, that influencer, quite often what you'll see is an opponent will say, I've paid for this influencer, I've paid for that influencer. What they then won't do is go and show the next step, which is, and this influencer has got this many followers, has got gets featured in these places, is an important person because. And finally, you need to have a main thread or a main story. I would say that pretty much every case has a small number of documents or a small number of assertions that win or lose the case for them, and you kind of need to understand how your case looks. Now, the other thing to say on the evidence, finally, is remember the balance of evidence. What you'll often see is somebody will put in a claim in the witness statement to a particular kind of turnover. They might say that they've turned over 600 grand, say, and what they'll then do is they'll say, oh, and here at Exhibit 1 are invoices that support that. And then what you'll go to Exhibit 1, and Exhibit 1 will have like 100 invoices, so 100 pages of their 300 page limit is taken up with invoices, and you just think, God, that's a complete waste of time, particularly when you then you look through the rest of the witness statement and you see that there are other things which they should be arguing or showing, and either they don't show it at all, or they don't really have enough examples of it, so the balance is all wrong. And that can sometimes have a really bad effect, because there is a rule of evidence that says that evidence is going to be weighed according to what you would expect to see and what was in the power of the person who's giving the evidence to provide and the person who's contradicting it to contradict. So if you are the brand owner and there are, say, 15, 20 things that you'd expect to show in evidence, but because of page limits, you show 100 invoices, you only show 2 print adverts, and then you're asking the tribunal to assess that you've got good repute. They're going to say, well, no, because actually there's not enough evidence on this particular point, and a good advocate will point out the fact that they had the opportunity to put all this in and it wasn't there, and so the tribunal can reach a negative inference that evidence just isn't there. What people tend to do is they'll put in the evidence they can get easily, and invoices are generally very easy to get, at the detriment of the things that they can't get very easily. So they'll assume that just because there's a lot of evidence, that means it's good evidence, and that's just not true. Quite the opposite sometimes. Now, once those witness statements are done, most firms will leave the whole consideration of the evidence and move on. They'll just get ready for trial. They'll get ready for the hearing. But I think that's a mistake. Actually, what you should be doing is going back and looking at your original statement of case again. Here's what you need to jettison the slugs. And if you don't know what that means, there's a story that came from a judge where he said, look, when you present your case to me, all your good arguments are like pieces of cake, and all your bad arguments are like slugs. And the more slugs you have on that plate, the less likely it is that I will want to take a piece of your cake. So, firstly, if an argument seems poor, even when you've done the evidence, just drop it. If it's really not going anywhere, drop it now. It does take some bravery, because it means you need to know what's good in your case and what's really not going anywhere, but it makes that case more credible. Precision really is more persuasive. If I say to you I've done a lot of cases in the IPO, then the answer's like, oh, okay, yeah, right. But if I say, look, I've taken 15 cases to a full hearing over the last 3 years, more than any other attorney, and I've got a win rate of 90% suddenly that becomes much more credible, much more persuasive. You need to review the actual statement of case itself. Are all the dates in there? So if you've claimed use since a date, is that shown on the evidence? Have you contradicted it? Quite often you'll see that the witness will say, we started using the mark in a particular year, and you look back at the statement of case and they claim use from a completely different date. Now, sometimes it's later, sometimes it's earlier, but they just don't line up. So you need to deal with that. You need to look at whether any arguments, not necessarily an entire case, but a particular thread of argument needs dropping. So if you're saying that there would be detriment and you just can't show detriment because there just isn't a good explanation why, you might want to drop that. And sometimes you might even be able to add something. Sometimes it can be a new ground if you've forgotten to put a ground in, but most of the time that'll just be extra detail. So now, once you've got all of your evidence right, you've looked through your evidence, your statement of case is cool, the other side's evidence really doesn't hurt you, and you're ready to go to the hearing. How do you then prepare for your final submissions or your final hearing, and what do you do about appearing? Well, first thing to say is there is a choice as to whether you appear in person before the hearing officer. Both sides get that choice. If one of you wants a hearing will happen. Even if the other side asks for a hearing, you still don't have to go to the hearing. You can just do written arguments. What I'd say is, if the case is one where it's, where the goods and services are clearly identical or very, very, very similar, and it's just about whether two marks are similar or not, most of the time it's not worth a hearing. Because the hearing officer, they have eyes, they have ears, they will work out for themselves whether or not two marks are similar or not. So if there's nothing else adding to it, there's no evidence that you've got, or that from the other side that they've got enhanced distinctiveness, these aren't specialist industries where you need to educate the judge. Just leave it at written submissions. As I say, don't spend time arguing whether two words are similar, unless there's a special reason to say that's not clear. So if there is something about the way that marks will be pronounced, if there's something about, something about a particular image on a mark that matters more, or means that it's not really very useful, and actually the word bits are more important, then just don't argue it. Just leave it and just let the hearing officer reach their own conclusion on that. When you're either putting your written submissions in and you're drafting them, or when you're thinking about your oral submissions, adopt what I call a MECE structure. Now, if you know what a MECE structure is, that's something which came out of a number of consulting groups. It's the way they do their reports, and it stands for mutually exclusive, collectively exhaustive. So, in other words, say it once, say it all. Make sure you cover all your points, but don't. What you see is a lot of opponents talk about a particular issue. So they might talk about proof of use, if you've got a mark where you need to show that it's been used because it's of a certain age. So they'll show that. They'll talk about the use under proof of use. Then they'll go back and they'll want to talk about it again when it comes to enhanced distinctiveness. And then they'll go and they'll want to look at it again when it comes to repute, because they've added in all these grounds, and the structure will just not be right. Look at the evidence once and then argue about whether or not it fulfills all the criteria. Find the thread, the theme, and any human emotions. Now, before you go in for the hearing, or you will have to do a skeleton argument. That skeleton argument should draw out the thread, the theme, and any human emotions. You should do so in a way that isn't obvious, but every case has got a story underlying it, or at least on paper. Even the driest cases have a story in them. And then finally, if there is going to be a final hearing, and if you are going to get somebody in to do it, just make sure that you choose a firm or an attorney that has appeared multiple times in front of hearing officers. And I say multiple times because there are a smallish handful of hearing officers. Most attorneys haven't had the experience of hearings at all, but let alone multiple ones. And there's a real benefit to knowing how these different hearing officers work. So, without naming any names, for example, one hearing officer generally writes most of his decision before the hearing actually happens. And then he will use that hearing just to check his understanding of the case and to test any points that he doesn't really think either have been addressed well, or he doesn't agree with what the parties are saying. Then there's another one who's a hearing officer who's more liable to listen really carefully to what's being said and ask a small number of killer questions that you absolutely need to get right. But this hearing officer knows their own mind, and so you're unlikely to sway them because they've done so many hearings that they know the law. You're really just, all you can really improve your case on is the evidence, and it's the presentation of the evidence that matters in front of that particular hearing officer, because the law is not something you're going to be able to convince them about. And then finally, there's another example, hearing officer who will pretty much stay silent throughout the entire hearing, but is definitely malleable as to both the law and the evidence. So if you can get a really strong structure and you can pull a really good thread into the case, and you can present the evidence in a way that it really fits with that structure, then the chances are you're going to succeed. So what we've looked at is how people get their evidence wrong, how you can improve it, And hopefully, if you do all of this right and you spend the money getting the case right at the outset, you won't spend as much on the evidence gathering, and you'll get a better outcome from the case. So if you do have any questions, please do feel free to send me an email. My email is aaron, AARON, at wood-ip.com. I'm happy to answer any questions you might have. And of course, if at any point in the future you do have a case where you want me to have a look at it, see whether the evidence and the grounds are good, or perhaps you might want me to appear in that final hearing for you, then just get in touch. That's aaron at wood-ip.com. And otherwise, I wish you a good day. Thank you.